It depends. This is a fairly complex area of law. So let me start by making the observation that there are different kinds of tax debt. Some tax debt is never dischargeable in bankruptcy, and the simple example is what are called trust fund taxes. So a simple example of a trust fund tax, payroll taxes. Let's say you have a business and you've got employees. And when you write their paychecks, you take money out of their paychecks that you hold in trust for the taxing authorities, whether it's the IRS or here in California, the Franchise Tax Board. That money is never yours. That is held in trust for the taxing authority. Suppose you don't send it to the taxing authority. You have violated that trust. Now you owe that money to the taxing authority. That can never be discharged in bankruptcy. You violated the trust. The most commonly discharged tax debt in bankruptcy is income tax debt. And income tax debt falls into several subcategories. The first is a secured income tax debt. You might think, wait a minute, secured? What collateral is there behind this income tax debt? The IRS has, and the Franchise Tax Board has the right to record liens, tax liens against your assets. So if, for example, you have a home and you owe Uncle Sam a bunch of income tax, Uncle Sam can record a tax lien against your property. That's now a secured debt. And so anytime you decide you want to refi or sell the property, as part of that transaction, you're going to have to pay off that tax debt. Is that a dischargeable tax debt? Well, it depends. But remember, it's still secured even if it is dischargeable. So let's put the secured tax debt on hold for just a second and go to the three-part requirement for discharging tax debt in bankruptcy. And all three requirements must be satisfied. If even one is not satisfied, you lose. Requirement number one is referred to as the 3-year requirement. What it says is that the tax return for the given tax year that you're seeking to discharge must have been due, with extensions if you got them, at least 3 years before the day you filed your bankruptcy petition. And it's down to the day. If you're off by even 1 day, there is no mercy. There is no, well, we'll cut you some slack. Think of the Terminator movie where the Terminator is just going to keep on coming. It cannot be bargained with. The second requirement is the 2-year requirement. Now, you might have noticed when I described the 3-year requirement, I said nothing about whether or not you'd actually filed the return. I focused on when the return was due. The second requirement says you must have filed a legitimate, non-fraudulent tax return for the given tax year at least 2 years before the day you file the bankruptcy petition. Once again, it's down to the day. If you're even 1 day off, you lose. The third requirement is the tax you're seeking to discharge cannot have been assessed or have been assessable during the 240-day window immediately prior to the day you file the bankruptcy petition. Now, since 8 times 3 is 24, 8 times 30 is 240, so 240 days is 8 30-day months. What does this mean about assessed and assessable? Well, let's deal with the assessment first. You send in your income tax return, and it gets to, I'll focus on the IRS. It's analogous with other taxing authorities. They get that return, and somewhere along the line, somebody there looks at it and says, hey, wait a minute, you owe us money. Well, that person types into the computer system an assessment. That is an assessment. You owe the IRS that money. A little on down the line, the IRS takes a look at your records and sees, You had income of $40,000. You didn't report it on this tax return. So they open up an audit. Now, that could be a couple of years after that original assessment, but there's more tax that's still assessable. Once the audit is completed, well, now we take a look and see, did you owe more tax? Yes, the IRS says, and so does another assessment. How on earth are you going to know about this assessment? What you have to do with the IRS is go to the IRS's website and get the tax transcript for that given tax year. And it's a special kind of transcript called the account transcript, which will give a chronological history for your Social Security number for that given tax year. And we can take a look at that transcript and get some sense of what the chronology must be for you to discharge that tax debt in the bankruptcy. What happens, though, if you didn't file a return? If you didn't file a return, you can't satisfy that 2-year requirement. Well, later on you file a return. How about that? That's an area of law that's still sort of developing around the United States. In order to understand what's at stake here, there is something that the IRS will file called a substitute for return. So you haven't been filing that return for the given tax year. The IRS is drumming its metaphorical fingers on the table. Finally, it gives up and says, looks like you're not filing. They file a return on your behalf, a substitute for return. The acronym is SFR. If that happens, you're not getting rid of that tax debt in bankruptcy. Now, to add an additional layer, if during these time windows you were in something called an offering compromise, or you had a prior bankruptcy case, that tolls the ticking of those clocks. So you have to get past the tolling period, or 90 days if there was a prior bankruptcy case. So the timing becomes absolutely crucial. And remember, there is no mercy, none whatsoever. Now, if you're in other parts of the country, such as the Fifth Circuit, which is down south, Texas, Louisiana, Mississippi, if you file the return even 1 day late, you didn't file a return for bankruptcy purposes, and you can never discharge that tax debt. So what does this mean about this dischargeability with regard to, say, secured tax debts? Well, if you, let's say, do a Chapter 7 bankruptcy, you get the discharge. And it turns out that the tax debt that gave rise to the tax lien was dischargeable. Ha-ha! You have now gotten rid of your liability. Uh-oh. But you haven't gotten rid of the lien that's against your property. You might think, well, wait a minute. I mean, if the tax debt is gone, why is there this lien? That gets into something that's a little counterintuitive if you're not sort of steeped into this whole business. We make a distinction between two kinds of liability in bankruptcy. One is referred to as in personam liability. The other is referred to as in rem liability. A simple example will illustrate what I'm getting at. Let's say it's time to go buy a car, and you trot on over to the dealership, you see the car you want, and they quote you a price, and you reach into your pocket and you realize, oops, I don't have the money to buy it outright. So what do? You take out a loan. When you take out that loan, two things happen. Now, they happen simultaneously, so you might not think of them as two separate events, but it is handy to bifurcate them into two separate events for conceptual purposes. Number one, the creditor gets a security interest in the car, meaning you don't make the payments, the creditor can retrieve the car. Number two, you as an individual become personally liable on the debt. What does that mean? It means if you don't make the payments and the creditor repossesses the car and turns around and sells it for less than you owe, it's coming after you to collect the post-resale deficiency. So that's a claim against you as a person, so it's called an in personam claim. The claim against the car is referred to as an in rem claim, and that's in part because the Latin word for thing in the appropriate objective case is rem. When you go through that bankruptcy, if you get rid of the in personam liability, it does not expunge the in rem claim against the asset. So this is where a little telephone law can help. It doesn't always work, but it can help. Sometimes after the bankruptcy is discharged, the case is closed for at least 30 days, and I get power of attorney. I can call the IRS up and say, hey guys, this debt was discharged. Would you please release the lien on my client's property? And sometimes they will say yes. So in that situation, you can get rid of that secured tax debt. Now, a debt that is non-dischargeable, you're just flat out not going to discharge. So if you get a discharge, the balance on that non-dischargeable debt it will survive the bankruptcy. So you have to satisfy all three requirements. In a plan, let's say it's a Chapter 13 plan or a Chapter 11 plan, that non-dischargeable tax debt does have to be paid in full throughout the plan. In Chapter 11, there's the wrinkle that it has to be paid in full within 60 months of the day you file the petition, rather than within 60 months of the confirmation of the plan. And this is where there's an additional little bit of a wrinkle. When we talk about priority tax debts, there are two factors that come into play. That 3-year rule that I mentioned and the 240-day rule. If either the tax return was due less than 3 years before the filing of the petition, then it's a priority tax debt. If the tax that you're seeking to discharge was assessed less than 240 days prior to filing the petition, then it is a priority tax debt. But it still could be dischargeable, interestingly enough, because that third factor that makes it non-dischargeable is found in a different place in the bankruptcy code. Here, that third factor says to make it non-dischargeable, you didn't file a legitimate non-fraudulent tax return within the 2-year window prior to filing the bankruptcy petition. If it's a priority tax debt, then you're going to have to pay it in full through the plan, even though it might be dischargeable because you did file the return within the 2-year window. In any event, this is a somewhat complicated area of law, so it's a good idea to spend some time with a competent attorney. And while I'm happy to present this in this video is not going to give you all the ins and outs of discharging tax debt in bankruptcy. The subject is anfractuous, and there are lots of traps for the unwary. So give me a call if you do have issues with tax debt that you'd like to consider discharging in bankruptcy.